Right, a very good morning. Just as an opener, the former minister was just dropped off a few seconds ago here at 9:30 here at sort of Crown Court. Right, so let's get straight to it. 45 minutes to starting. Number one, defense did not finish his submission yesterday. That's Jonathan Laidlaw. He couldn't finish yesterday despite having the floor all day. And so, but he did promise that today is not going to take more than an hour. Right. So let's just hope that by noon he will have finished his submission. And before giving you how yesterday panned out, he did say 9 things, 9 contradictions, which he promised to bring out before the jury in the Crown's submission. Those are expected this morning. So he didn't reach to those 9 contradictions, which he said the Crown's case is a case of contradictions. And he said 9 of them is going to close with that this morning. But yesterday, before also telling you how yesterday panned out, in property, they say location, location, location. In investment, they say follow the money. It was something similar yesterday when the defense barrister was telling the jurors as a continue. So yesterday was the second day, of course. On Tuesday, when he started his closing speech, it was like half day. That was after the Crown had finished our own closing speech. So yesterday, when he continued with his speech, Jonathan Laidlaw, King's Counsel, told the jurors the first thing he said as a backdrop was that British criminal justice system is broke. I mentioned this over a month ago during one of the delays which we had. We had shown up in court then, and there was a delay which we are not allowed to tell you the reason. And I did say that, look, these are the things that add up to the delays, which of recent, earlier this year or late last year, where a respected retired justice did a review, and the report was that British justice system is overwhelmed. There's too much delay. So that was what Jonathan Laidlaw opened with yesterday. He said the British criminal justice system is broken. He said it's broken. Not only is it broken, he said it is skewed against a defendant. It is skewed. And he said, look, the delays that his client is having to deal with, she should not have been confronted with that disadvantage. So that was just like an opener. That was just a backdrop which he gave to the jurors, just to let them say, British criminal justice system is broken and it is against defenders. So he just opened the floor yesterday morning with that. Number 2 is that we then told, like I said, in property, they say location, location, location. In this case, as it started yesterday, Jonathan Laidlaw, King's Counsel for Diezani, said, look, you folks here, you must follow the evidence. You must follow the evidence. That is why the judge, as I repeatedly told them, don't research this case. Don't read about this case. And the defense told them yesterday, you must follow the evidence that had been tabled before you in this court. And he also told them, he said, look, your oath, you took oath. You must be guided by the oath you took in January. That this case is not about your impression, but about the evidence in this courtroom. So he reminded them of that yesterday. He laid those 2 foundations. And number 1, and they say, of course, in football or in boxing, they say defense is the best form, attack is the best form of defense. The counsel for Diezani continued yesterday after laying those backdrops there, he then attacked the submissions of the Crown. He said, look, one of the submissions of the Crown was that when Diezani was interviewed after her arrest in 2015 and subsequent interview, that she had no comment. She didn't make any comment. The Crown prosecution argued then when she was closing her speech that she didn't make any comment because she had nothing to say. And she knew that if she said anything, that the evidence against her was overwhelming. That was why she had nothing to say until her lawyers came on the scene and she was responding with written comments. Her defense said, look, that is not the case at all. That this was somebody you are asking to make comments, and then she didn't have access to ministerial diaries. How do you expect her to be making comments? So it first of all nullified that argument that the Crown prosecution made in her closing speech. She made that also severally while she was she was presenting her evidence. And then the judge, the defense said, look, I'm going to give you 6 areas which is going to argue to close this trial with. And he said, you must be guided by evidence. He said that. And also, number 2, he said, the importance of good character. They must take that into consideration. That is also part of the written direction that our ladyship gave the jurors. Remember when the judge was giving a direction, he said, good character is part of it. When you are in doubt when you have to use common sense, when you have to make an assessment that is not entirely on evidence, good character, fairness must be taken into consideration. So the defense for Diezani mentioned that you must be guided by evidence, by good character, and the written direction of the judge. Don't go outside of this. Follow what the judge has said. And also, more importantly, he said, look, the burden of proof is on the prosecution, as the judge also had said to them. The burden of proof is on prosecution, not for them to say Diezani didn't do anything, but those are just preambles, those are just the defense did not actually rest on that. Having said all those, he said, number 1, the NCA, the Crown prosecution really dismantled the submission of the Crown and the NCA, what they had done in the investigation. He said, number 1, he said, nothing. All they are prosecuting his client for is based on shopping, Harrod shopping in high-end stores. He said, that is all you have brought this case about: shopping, flight, school fees, and then those are the things which the Crown's case is built on after over 10 years. He said, number 1, they must also take into consideration delays. So he said, those things he mentioned, and he said, not for once did the Crown bring somebody to come and testify from NNPC, because remember, Diezani's case is that reimbursements were made for the 6 people that were said to have bribed her or given her unfair advantage. He said not one single evidence did the Crown call from somebody who was in NNPC during that period of 2011 to 2015 to come and testify whether there is a system in place for reimbursing the things, the payment made, the shopping made on her behalf. He said not one single evidence. Not one person was called by the Crown. And not only that, that the Crown also ignored this in their closing speech because, number 1, because their case is just, in fact, he said their own case, just as the Crown has said that Diezani's evidence is rubbish, the defense for her said the Crown's case is equally rubbish, nonsense. That was how he called it. He said they did not even call one witness from NNPC or from Ministry of Petroleum to come and say whether there was a system in place to corroborate to what the minister said, that reimbursement was made for Kola Loko, for Gideon Mokore, for Kevin Ongere, for Prince Momo, Igo Sanomi, and all the 6 men that were alleged to have bribed. I said the Crown did not call one single evidence or bring somebody, just even one person who was in NNPC between 2011 and 2015. He said all the Crown relied on was shopping and the emails from Tenka employees. Tenka is a company owned by Kola Loco. He said they didn't bring one single witness from NNPC or from Ministry of Transport to come and say whether there was a system in place or not. She said, look, so he said, Crown's case is complete rubbish. That was what he said. But that he didn't even raise it. He said, when there was a proceeding about reimbursement in Nigeria a couple of years back that Igo Sanomi produced evidence in court that he was reimbursed. He said, NCA, National Crime Agency, they have access to that written document. He mentioned the reference. He said they ignored it. They didn't bring that reference. They didn't bring the exhibit. He said, so there was a system in place for reimbursement. I said, it is on you, the Crown. You should have done this, but you didn't even produce one single evidence. You didn't even bring one single witness to come and corroborate or deny whether there was a system in place for reimbursing all the shopping. He said, all your case, all your evidence is based on shopping in Aros, Thomas Good, and all they said you didn't bring somebody from NNPC or Ministry of Transport after over 10 years of delaying of investigation to come and say whether there was a system in place. So it did lay that foundation and it did emphasize it. I said, not only that, you did not even get the bank statement of these 6 men to show whether they were reimbursed. So he also mentioned that. So that is why he told the jurors, he said, look, follow the evidence. He said the Crown did not produce one single statement of Kola Loco or Gideon Mokore to see whether they were reimbursed for the handbag, for the things, the shoppings, which they said, which they did for the minister, the former minister. And he said, look, those things also that you said, all those shoppings that you displayed, he said, look, number one, during cross-examination, Diezani was in the box for 5 days and also cross-examination for 5 days. He said, my client was cross-examined and she told you not all those shoppings were for her. She admitted some. She said, look, number one, the fact that somebody's card, reward card, those points went on them. He said, number one, Kola Loco has many girlfriends. Sometimes the reward card points for the shopping he did, you transfer them elsewhere. He said probably, just to hide it from his wife, So, and he said not only that the Amila, the prosecution witness, one of the main witnesses, Amila from Harrods, who was a personal shopper, on the field. She said she told you in court that it's only about 5 or 6 times that Kola Loco came with Diezani, that other times Kola Loco came shopping by himself, he came with his wife. So all those shoppings that you displayed, definitely they couldn't be for Diezani, but more importantly also, he tendered the evidence that the Crown brought that those shopping were found in Apapa. Some of them were found in the storage owned by Diezani in Lagos. He also tendered that evidence. He said, look, the names on those cargo, they were for Gideon Mokore and Kola Loco. So definitely, so he also dismantled that Crown exhibit. He said, look, this, he brought them out, said, look, who were this addressed for? They were addressed to Kola Loco and to Gideon Mokore and also to his counsel. He said, look, so these shoppings that you displayed, they were not entirely for Diezani. So, and he said Diezani told you that she admitted that when he laid down evidence and when the Crown prosecutor, cross-examined her for 5 days. So he said, number one, you did not even bring one single witness. You did not bring one person from NNPC or from Ministry of Transport. You didn't produce one person. You said, look, my own client was in the witness box for 10 days. I laid down in evidence and you cross-examined her and she told me, said, this is it. So that is why I was telling the jurors, said, follow the evidence, follow the evidence. You swore to an oath that you follow the evidence and you follow the written direction of her ladyship. That is what she said. And also he attacked the flight that was said to be improper advantage. 4 flights, two of those flights, I'm going to touch them in this briefing. Number one, the flight that was to go to Hamburg, between Hamburg and London. That flight was, Diezani told the court and also during cross-examination, he said that flight was at the instance of President Goodluck Jonathan to go and see former President Ibrahim Babangida, who was receiving treatment outside of Hamburg for cancer, and that the president said they should go and see her. And Diezani said they spent about 3 hours seeing her. So in fact, that doesn't even make sense that if somebody is going on a presidential visit and to say that is improper advantage. So he also said that, he said, NNPC, they are the people that organize this flight. It is not for a minister to be arranging a flight. That number one. And secondly, most importantly, that these people were reimbursed. Kola Loco, his company was reimbursed. He said, you, the crown, the burden is on you. You should have produced bank statements of Kola Loco's company to corroborate or disagree that there was a reimbursement made to him. So he dismantled completely the core evidence of the crown. That is number one. And then another flight which was also counted as advantage. This was a flight when Diezani was to be made to take the presidency of OPEC, and that was a chartered flight. The Crown also cited that as part of improper advantage. He said, number one, again, that doesn't make any logic sense. Somebody is going to become OPEC president, so if a company has arranged a flight, that is not a personal advantage, but the Crown brought that up as an advantage for her, which they said was improper. I said, look, this is not something, and Diezani explained during cross-examination that OPEC specifically said when you are coming to Vienna, you come with private flight, that there was a different place where private flights are received, not the commercial. So that was why NNPC arranged that, because the first time she went for OPEC meeting, they landed in the general airport, and for security reasons, when ministers are coming for OPEC meetings, they have just like you go to airport, you have VIP departures and arrival. I said that was the reason that flight. So those are 2 of the 4 flights. In subsequent broadcasts, I'm going to mention the other 2, but he said, look, those flights also, and if you are saying they were Kola Loco and his company and Kevin Onyele's company were not reimbursed, you should have produced their bank statement to say, yes, there was no reimbursement. So he said, despite the burden of proof being on you, the prosecution, we are telling you that there was reimbursement. Diezani believed they were reimbursed. So the Crown, if they didn't do a lousy job, he said, you should have produced statements. He said, not one single statement you didn't produce. All you did was to be producing shopping that she did. And my client has said, these people were reimbursed. If you wanted to disprove it, if you wanted to say, this is not the case, you should have produced bank statement of Kola Loco, or you should have gone to where the bank statement of Gideon Correa to say there was no reimbursement. You didn't do this. And he said the Crown prosecutor also ignored this in her closing speeches because she knew there was nothing. Their case is contradictory. He said that was why she did not touch it at all. She said she even did not touch on the evidence of Amina, the Harrods personal shopper. They said because the Crown did not touch on this because they knew their case was nonsense. So he said, those are the things he said. He couldn't finish the 9 contradictions which he said, which are supposed to be the big blows. He's going to deliver them this morning. He couldn't finish yesterday. He said, this morning, I'm not going to spend more than half an hour to finish my case. And he said, so he told them, and also there was agreed fact number 40. Let me read that to you. Agreed fact number 40, which the Crown said we are not suggesting that the former minister did anything improper. He said this is an agreed fact that the Crown said we are not suggesting she did anything proper. So how come again you are putting her on trial and say, look, somebody has been delayed for 13 years, and now the agreed fact number 40 is that we are not suggesting that she did anything improper in the award of contract. So now, again, that is contradictory to what you have dragged her here to come and be prosecuting. So he picked those holes one by one, and if this was a football match, probably the Crown would not have come out for the second half of the injury time. But those are how the defense for Diezani argued their case. And don't forget, he said 9 contradictions in their case. I'm going to produce it. He said, again, so the key point is that you didn't produce any of the 6 men that you said bribed. And actually, 2 written statements from Kevin on which they said, bribed her. Kevin said he wasn't bribed. Kevin said there was reimbursement. He said, Crown, you should have produced his bank statement to see whether he was reimbursed or not. Diezani, he had a proceeding in Nigeria in court. He tendered evidence, and the Crown, the defense reminded the court, he said, look, NCA, they had access to that proceeding, to the exhibit that Diezani produced in a case in Nigeria to say it was reimbursed. He said, NCA, they have access to that evidence, to that receipt that Diezani produced in Nigerian court, that NCA did not bring it because they knew their case was nonsense. So he told them, he said, look, this is what we are saying. So that is why I told the jurors, he said, follow the evidence. Follow the evidence. Whatever your impressions of my client, follow the evidence. You swore an oath to be fair. That is what I expect you to do. And also talking part of the written direction of the judges, fairness, good character. I said, these must be taken into consideration. He says somebody who had become OPEC president, the likelihood of her wanting to do anything criminal is very unlikely. So he said, look, also part of the written direction is that when you are in doubt, follow good character. So he said that, and also President Goodluck Jonathan did say that this, my former minister, this is somebody of good character, somebody who has shattered the glass ceiling, the first woman president of OPEC. How do you expect that she would then be doing something criminal? So he said, so if you have to make a judgment on good character, on common sense, he said, you must follow. This is what the judge told you to do. Follow the judge's direction. Follow the oath you swore and follow the evidence. So that's how the defense argued his case. And this morning, he hopes to finish up by bringing out those 9 contradictions in the Crown's case. So I hope to see you then.